this morning to look at an immigration law update. What I'm going to do is just take you through some of the significant changes that are actually due to come in this week. These all stem from the current government's plan, 5-point immigration plan that was announced back in December of last year, and the key aim of that plan is to reduce net migration. I don't think it's necessarily a surprise that the government is taking this tack because we are in an election year and immigration is always one of those areas that becomes quite a hot topic in these kind of times. So unfortunately for employers that are keen to use immigration to fill some of their shortage gaps, you are going to feel, I think, some significant changes which may bring in difficulties for some of your plans for hiring new talent to the business. So the changes that we're going to look at, we're going to focus on the skilled worker route and particularly the plans to increase the salary threshold for the skilled worker route. We're also going to take a look at the shortage occupation list and the changes that are afoot with that, particularly because the engineering sector currently benefits quite a bit from its inclusion on the shortage occupation list. So we'll touch on that. And then lastly, it's just to flag something which I'm sure you're all aware of, but it was changes to the civil penalty scheme, which came into play in February of this year. So if we start, first of all, by taking a look at the skilled worker changes. So the salary threshold, this is the big headline change that's coming into force this Thursday, the 4th of April. And the minimum general salary threshold for visa sponsorship under the skilled worker route. So this is where you as an employer will hold a license with the Home Office and can then sponsor the visas of staff in the United Kingdom. Now, currently, the general salary threshold for visa sponsorship is 26,200, and it is going to increase almost 50% later this week to 38,700 per annum. In addition to changes to the general salary threshold, there are also changes to what is known as the going rate. So what the going rate is, it's the occupation specific salary. So each occupation, each particular role will be assigned a going rate by the Home Office. And that would be one of the markers in terms of determining how much you have to pay an individual under the skilled worker route. Now, currently, the going rates are calculated with reference to the 25th percentile of salary data, according to the annual survey of hours and earnings. That is changing as of later this week, and the salary rates are going to be calculated with regards to the 50th percentile, so the median salary. So it will see, and we'll look at some examples of how this is practically going to affect business later on, but it is going to also result in a huge hike in salaries in certain roles. Now, with the changes, there is a lot of transitional provisions. So the immigration rules, the draft rules that have been published, setting out these changes, run to 300 pages. So you can imagine the level of detail that has been included in the changes to the rules. So we will look at that in some detail, particularly focusing on what happens to you who have staff that are already sponsored under the skilled worker route and how their sort of immigration paths with you would look under these new rules coming into force later this week. But before they do that, I just want to give you a kind of overview of where things are at, so you can kind of compare the two, the current situation versus what we're going to be facing next week, later this week. So at the moment, when you're looking at visa sponsorship, you have to pay the hire of 26,200 per annum, the going rate, whatever that might be for the role, and £10.75 per hour. Now, there are possibilities to trade points. So this is where you can get a reduction on that going rate or on the general salary threshold, depending on any particular characteristics that your applicant might actually have. So, for example, jobs that require a PhD will see a reduction, and that can be between 80 and 90%, depending on whether it is a STEM PhD or another type of PhD. New entrants who are your graduates, new to the work environment or under 26, for example, at the day of application, they also benefit from a significant reduction in salaries. They get a 30% reduction currently, and then jobs that are on the shortage occupation list currently get a 20% reduction on salary, both in terms of the general salary threshold and the going rate for the role. So fast forward to Thursday, it's going to look slightly different. So the going rate, as I said, we'll look at these individually, but they're going up generally across the board. The Home Office has reclassified the standard occupation codes, so they're being renamed Standard Occupation Code or SOC Code 2010 to SOC Code 2020, and then we'll have the rate set at the median rate rather than the 25th percentile. And then the general salary threshold was going up to 38,700. So you'll note as well on the table there isn't a separate hourly rates requirement. And that's because this is how the rules are drafted. There is no additional requirement to be above a certain hourly rate per se, but actually what has happened is the going rates have been set so that the minimum hourly rate across the going rates must be £15.88. So effectively that is your minimum going rate, £15.88 an hour. So again, massive increase on the current £10.75. But we do have transitional provisions. So the new rules, basically, those higher salary thresholds will apply to individuals that are applying to the route for the first time. So this will be either someone who you are hiring from overseas, who's coming to the UK as a skilled worker for the first time, or someone who is already in the United Kingdom with permission in a different visa route. So that might be your international students, or you might have someone on a graduate visa, family type visa, whatever that is. Individuals here switching into the route for the first time will have to be paid at that higher salary threshold of 38,700 per annum. But those of you that have employees that are already with you and sponsored under the skilled worker route do have slightly more lenient provisions. Now, when the 5-point plan was initially introduced back in December, we were told that people already in the route wouldn't have to meet the higher salary threshold, and so everyone was a bit more relaxed about what that would mean going forward for existing employees. The transitional provisions, as you'll see, aren't actually as generous as what they thought they might be, so they will invariably mean a higher salary threshold will need to be paid. So starting off, who qualifies for the transitional provisions? Well, basically, it's anyone who's got permission in the UK under the skilled worker route before the 4th of April 2024. So that's when the changes come in. So as long as that individual is making an application for an extension of stay as a skilled worker before the 4th of April 2030, so they've got 6 years to benefit from these transitional provisions. And they had permission as a skilled worker before the changes, and they've continued to have permission as a skilled worker since then. They can benefit from the transitional provisions. So if you had someone who's a skilled worker but then switched into, I don't know, a family route, spouse or British citizen, and then switched back to the skilled worker route, they would have a break in their continuity of residence as a skilled worker and therefore wouldn't benefit from the transitional provisions. Where we've got these transitional provisions, the salary thresholds are slightly reduced. So instead of having to pay 38,700 per annum as the minimum general salary threshold, you would have to pay 29,000 per annum. So it's still an increase on the current minimum threshold, which is 26,200. The other requirement is that they're paid at least the going rate for the role. So the going rates are also different to what they currently are. So at the moment, as I said, the going rates are set against the 25th percentile of the annual survey figures. They will continue to be set at the 25th percentile, but the 25th percentile has been updated in line with today's most recent figures. So essentially that also means there's going to be an increase in the going rates across the board for these roles. The ability to use tradable points, so again, reducing the salary threshold, is available for those who are covered by the transitional provisions, and so that will reduce the minimum salary threshold to, in most cases, 23,200, but some cases it will also be 26,100. So that's someone who is reliant on there being a requirement for the role to have a relevant PhD in a relevant subject area. Now, the tradable points, however, it's really worth noting that tradable points are not available for settlement applications. So a settlement application is when one of your workers is looking to apply for permanent residence in the UK, which will typically be after a period of 5 years in continuous residence as a skilled worker in that route. So they won't benefit from tradable points, and therefore it'll be the higher of the 29,000 per annum or the going rate for the role, whichever is the higher of the two. The next big change, and I think one that definitely will affect the engineering sector, is changes to the shortage occupation list. So at the moment, the shortage occupation list is a list of over 50 different roles, occupation codes, which get a reduction in the going rate and the general salary threshold. So there's a 20% reduction by virtue of being on the list to both those salary requirements for the role. The shortage occupation list has been, will be as of Thursday, deleted, and it's being replaced by something called the immigration salary list. Now, this follows the Home Office's request to the Migration Advisory Committee, who advise government on migration policy, to review the shortage occupation list. And this is a very sort of rapid review that's been undertaken, and there will be a more detailed review by the Migration Advisory Committee later this year. So it's possible that there's still going to be further changes to the newly constituted immigration salary list. But basically, as a result of the review, the amount of roles has reduced significantly. So we're looking at just over 20 positions now that are now on the new ISL compared to the shortage occupation list. So less than half of the roles have been withdrawn from the list. That includes all of the engineering positions that were there. So your civil engineers, project engineers, all of those positions that are on the current shortage occupation list will not appear on the immigration salary list. And basically, the MAC took the view that there's not a benefit to include those roles on the list. And the reason for that is because with the new higher salary threshold, what's happening is where the role is not going to benefit from being on the list, there's just no need to put it there. So under the new rules, the 20% salary discount on the going rate will not apply. You'll only get a 20% discount on the actual minimum salary threshold. So a role will have to be paid the higher of the 20% reduction on the salary threshold, which is 30,960, or the going rate for the role. So all of the engineering positions with the revised occupation codes and revised going rates are above that reduced level. So there is no benefit to being there because you'd still have to pay the higher rate anyway. So that is a real big change, and I think something that we'll have to keep an eye on as a review is undertaken further by the Migration Advisory Committee. I think the other thing to say about the transitional provisions when it comes to the shortage occupation list is that there is scope for people who are currently under the skilled worker route in a shortage occupation list to continue to benefit from tradable points as you would normally do and get a reduction on your salary if your job is no longer on the shortage occupation list, but was at the time, but that only applies where the individual continues in employment with the same employer. So for example, you have someone who wants to extend their permission with you, they could benefit from a reduction in salary based on tradable points. But if that same individual wanted to move to another organisation doing a similar role, which previously, was on the shortage occupation, they would no longer benefit because they've changed employer and their sponsor is no longer the same. So I think just to sort of highlight these changes and make it a bit more digestible, I've just got some examples of what it actually looks like in reality. So the first scenario I've got is the role of civil engineer. So the current occupation code is code 2121. Now that is on the current shortage occupation list. So the minimum salary requirement as of today for that role is 35,100. And that is because it is the higher of the current general salary threshold, which is 26,200, or the going rate for the role. So the going rate is the rate that would have to be paid in that scenario, which is 35,100. However, because the role is on the shortage occupation list, it would be eligible for a 20% salary reduction to the going rate. So in effect, you could pay 27,760 per annum to someone on that occupation code. The new rate as of Thursday is significantly higher. So a new skilled worker joining for the first time, never been on the route before, instead of being paid 35,100 or in fact 27,760, they would have to be paid 45,500. So that is essentially the going rate under the new SOC codes at the median salary level compared to the 25th percentile. So it's a massive increase for that particular position. Where you've got individuals who are already in the route under the skilled worker route and are extending, they would have to still be paid a higher amount. So it's not as big an increase if you were comparing it against the current 35,100. It's 35,300, but it's obviously something to be aware of, particularly for those individuals that may already be benefiting from the shortage occupation reduction. So that would be a bit of a jump. The other thing to say is that when someone like this is applying for indefinite leave to remain in the UK, if they were applying under the transitional provisions, that they can't rely on tradable points. They would always have to be paid the higher of 29,000 or the actual going rate for the job. The next example I've got is that of a project engineer. So this is occupation code 2127 under the new rules. So this is another thing to watch out for. With the reclassification of the occupation codes and changing them from the 25th to the 50th percentile of the salary data, some of the occupation codes have changed. So you could be searching for the code that your staff member is currently on and then actually realise it's not the same. So that's something to be wary of.
Thank you very much. Cheers.
And the other thing to notice is that some occupation codes just aren't there anymore. They've been withdrawn. The engineering positions, however, they are all still there, the ones that are there previously, but there has been some changes like the project engineer switching from 2129 to code 2127. So with this occupation, the current minimum salary is 33,400, but again, it benefits from a 20% reduction on the going rate under the shortage occupation list. So it would be 26,720 at present. As of Thursday, again, we're seeing a hike, and the new minimum for this rate is higher than the civil engineering code, and it's going up to 48,800. And then for those that are extending, the transitional rate again is jumping quite a bit, up to 39,400. So the other thing to note is that the going rates for these positions under the new rules are still going to be calculated based on a 37.5-hour working week. So Any other working patterns when it comes to calculating the going rate, being at the right threshold, would have to be prorated in line with that 37.5 hour base kind of hourly rate calculation on the going rate. And then lastly, the last scenario I've got for you is I want to just sort of show you what it would look like when you are trying to rely on some of the tradable points. And I think many of you might have graduate schemes where you're relying on hiring international graduates who might be on a graduate visa or just finished their studies on a student visa. And so you currently get a reduction for them. So if we take the position of engineering technician, so that's currently occupation code 3113, and that's staying the same. So the current minimum salary for a new entrant, so you're a graduate, someone under 26, someone switching in from the student rate rules, for example, would be 20,960. So that's fine. That's, it's not a particularly high salary for someone coming out of university and starting a job for this for the first time. Under the new route, under the new rules, the new minimum salary for new entrants is 30,960. So 10 grand increase there straight away. The effective minimum hourly rate for the new entrants under the new rules is £11.90 per hour compared to the current £10.75. And then if you had someone who was reliant on transitional provision, so you've got someone who's currently a new entrant and would be looking to extend their stay as a new entrant, their minimum salary would also be higher at 23,200. However, there is a cap on the amount of time somebody can spend in the UK as a new entrant, and it's a maximum of 4 years, and that would include time as a graduate. So for example, if you have someone that you hired for the first 2 years on a graduate route visa, which is a 2-year visa, and then you switched them to the skilled worker route as a new entrant, they can only do 2 years on the skilled worker route. So the amount of people that actually would benefit from a reduction on extension of the new entrant rate, I think would be particularly low, because you probably will have maxed out your 4 years at the outset for someone in that kind of position. So in that case, if there were no longer a new entrant, they would then have to meet the general salary threshold for the role. So as a someone extending, it would be 32,900, or the general salary threshold, the going rate, sorry, for this role under the new rules is 39,800 compared to the current 29,900. So again, it's roughly a 10 grand increase on the current salary threshold. So pretty significant in terms of the level of salary changes. So moving on from that, the next thing I wanted to mention is just to flag, which I'm sure you're all aware, is that there has been changes to the civil penalty regime. These changes came in on the 13th of February this year, and basically we've seen an almost tripling of the penalties that will be handed out to employers. So the civil penalty regime applies to employers when you're employing staff. You are required to comply with the duty to prevent illegal working. You will do that by making sure, as part of your onboarding process, that you are verifying and checking your staff members' right to work in the United Kingdom. If you carry out a right to work check that is compliant with Home Office guidance, then you will receive something called a statutory excuse. So that means you have an excuse against any allegation of employing someone illegally and can avoid receiving a civil penalty. If, however, you haven't carried out the checks correctly, or you haven't done a check at all, and it transpires that someone is working in the UK without permission, then instead of receiving a fine of between £15,000 to £20,000, the new fine levels are £45,000 to £60,000. Now, those fines, 45,000 would be for your first breach. So first breach per worker, 60,000 is for repeat breaches, and that's in a 3-year period. So if it's been more than 3 years since you had a civil penalty, then actually it'd be 45,000, because you'd be back to the first breach. Now, previously, what used to happen is that you could get mitigation against these level of fines, and there was 3 different reasons. So, for example, cooperating with the Home Office, and you would get a reduction of £5,000 for each mitigating circumstances. So, effectively, you could get 15,000 by way of mitigation off of a civil penalty. So, in some instances, that could then mean you didn't have to pay anything. The mitigation levels that you get in terms of reduction are still the same. So, on a 45,000, if you did successfully argue any mitigation, you could still be looking at upwards of £30,000 per worker. So it's like significant amount for any organisation. And if you think about the potential for multiple breaches, then you're looking at over 6 figures in terms of what the level of penalty could be. So I think what I would just say is just do an audit, make sure that those that are responsible for onboarding within the organisation are aware of what the requirements are. The Home Office guidance has all been updated recently, so just make sure you're familiar with the current processes for conducting right to work checks to make sure you don't fall foul of these increased civil penalties. So where does that kind of leave us? Well, I think the next thing I would suggest really in terms of what you do when you go away is make sure you're aware of the current workers that may be affected by these changes within the organisation. Review the certificates of sponsorship that you have on for any workers and look at what the transitional provisions would be for them. Check what the salary thresholds are going to be. Check where they are in terms of their sort of immigration journey. Are they requiring an extension of stay? If so, when? Are they going to be applying for indefinite leave next? If so, when is that likely? So that you can try and see what their salary progression is going to have to look like between now and then, to make sure that that is something that's achievable for you. When it comes to thinking about new hires, then I think you need to think about the salary levels that are on offer. There may be certain roles that are in shortage and there's high demand for that you struggle to fill. So particularly those roles, knowing what it would look like should you go down the visa sponsorship route. Is that an affordable figure? Do you need to revise any internal budgets to take account of these salary increases? And then I think lastly, as I said, just make sure that your current right to work checks and your policy on how to do them is up to date to avoid the significant rises to the civil penalty scheme. And that's it, 2 minutes to spare. If anyone has any questions, I'm happy to take questions.
I think there was one in the chat box, Ashley, to get it started from Sheila Dunphy, if you can see that.
Yep, can I ask, sure. Can I ask if these apply to someone on an extended student visa? So if someone's on a student visa, they will be limited in the amount of work that they can do. So generally speaking, a student would be permitted to work 20 hours a week during term time and could work full time during the holidays. So this doesn't apply to them. So it only applies to people that are sponsored under the skilled worker scheme. So if you've got a student on the books that's working part time, then you would just be subject to your normal minimum minimum wage requirements, which is obviously just going up to the £11.44 an hour. But other than that, no. If you then wanted to sponsor that student under the skilled worker route, then yes, they would be impacted. They would likely benefit from one of the tradable points options as a new entrant, because if they've just completed their degree on a student visa, then that is possibly one of the new entrant possibilities, and in which case they would get a reduction. But it depends on the role whether it would make any difference to you, because the reduction would be to the general salary threshold, so it would be down to 30,960, or the higher of the going rate for the role, which is likely to be higher than that. So it would just kind of depend. You'd have to look at what occupation code you wanted to hire them on, and then have a look at the tables in the rules to see what salary would apply. But if they're just working for you on the student visa part time, then no, that wouldn't work. Oh, no. So she's not on a student visa then. If she's extended her, so just for everyone else, Sheila said that the person's finished studying, they extended her student visa on something that allows her to work for 2 years. So that sounds like a graduate visa. So someone who's finished their studies, extends their stay. It's not a student visa anymore. They're not required to study. They're here as a graduate, which is a 2-year work visa, which again doesn't require visa sponsorship. But it's a feeder route to the skilled worker route. So if at the end of those 2 years you wanted to keep them on, then you would again try to move them onto the skilled worker route. And again, they could be a new entrant, relying on the fact they were last granted leave as a graduate.
Thanks, Ashley. And does anyone have any more questions for Ashley before we wrap up? No, so I think if there's no more questions, then that's us for today. So thanks all, and thanks to Ashley.
Thanks, everyone.
Thanks.
Thank you.